Greetings, everyone. Greetings. Okay, I want to talk about an article that came out today that was published. And this article is an opinion by John Yule with Fox News. The article, as you can see, it reads, 2019 could be an incredible and historic year for the Supreme Court. Here's why. Okay. Now here's a picture of President Donald Trump and the First Lady Melania Trump and the Chief Justices of the Supreme Court, along with let's see here, along with Justice Anthony Kennedy. Okay, I'm going to read the article. It says this year ahead has the potential to be historic for the U.S. Supreme Court. With Justice Brett Kavanaugh replacing the inconsistent Justice Anthony M. Kennedy, conservatives have a majority on the court for the first time since 1936. More importantly, for the first time in generations, a majority of the justices on the court believe varying degrees in interpreting the Constitution according to its original meaning. This could produce a return of humility to the judiciary. For decades, liberals have pushed a view of the high court and a method of judging that is antithetical to our written Constitution. Founded on beliefs from the legal realism movement, still the primary approach taught today in American law schools, the left deems the law as just politics and power. Under this view, the courts are to worry about outcomes rather than the process of determining what the law means and applying it to the facts of the case. Forget about the ideal of blind lady justice. She has both eyes wide open to hand legal victory to the preferred party. This worldview was on display when President Obama said he wanted judges who had empathy. Of course, this was selective empathy, such as for racial minorities, unions, and criminal suspects, not for corporations or the police. But the Constitution demands a better way. As Chief Justice John Roberts suggested during his confirmation hearings, judges are like umpires, just calling balls and strikes. In other words, a judge's job is to follow the right process, not reach a preferred outcome. The outcomes take care of themselves. These two competing visions of the proper role of a judge lead to two very different ways of interpreting the Constitution. For the judge as philosopher king model, judges exercise the same power as legislators, free to change the meaning of the law as they see fit. Hence, the Supreme Court can write its own values into the Constitution. For the judges as umpire model, however, the court does not make the law. Rather, it determines what the words of the law meant at the time of the law's enactment and applies that meaning to the case at hand. This methodology of discerning the law according to its original meaning is called originalism. When dealing with the Constitution, and textualism when dealing with statutes. And in some form or another, this way of judging goes all the way back to our nation's founding. From Constitution's perspective, originalism is superior to an approach where judges just implement their policy preferences. There are at least two reasons for this. First, originalism is the only legitimate way for judges to exercise the judicial power granted them by the Constitution. That power is abused, or more accurately, legislative power is usurped if, as Alexander Hamilton warned, courts exercise will instead of judgment, the consequence being the substitution of their pleasure to that of the legislative body. Second, allowing courts to bend the law to their own desires weaken the republic. And I agree. The power to amend the Constitution was left with the people, the sovereign, to be exercised through state constitutional conventions and their respectives in Congress. President Abraham Lincoln warned that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Now committed to originalism, a majority of the Supreme Court can begin the process of restoring the Constitution to its original meaning and returning the judiciary to its place as the least dangerous branch. And that restoration may well begin in 2019. Perhaps the most immediate area, but also the most influential, will be cutting back the administrative state. The federal government has swollen to a gargantuan size, with numerous federal agencies passing tens of thousands of pages of regulations every year that never undergo approval by the House and Senate and signature by the President. When designing the Constitution, the founders understood that the accumulation of power can lead to tyranny. To prevent this, they diffused power at the federal level by creating 3 branches of government exercising 3 different powers. The founders also diffused power between the federal and state governments. This created what Madison called a double security for the people's liberty. For the people's liberty, okay? For the people's liberty. But President Woodrow Wilson introduced the idea that these constitutional protections have become antiquated and inefficient. Accelerated by President Franklin Delano Roosevelt during the New Deal, our government evaded the separation of powers by concentrating all 3 powers, executive, legislative, and judicial, in federal agencies. The Supreme Court can put a stop to this in at least 3 ways. First, in this term's Gundy case, the High Court can once again enforce the Constitution's separation of federal power among the 3 branches by resuscitating the non-delegation doctrine. Simply put, that doctrine holds that one branch of the federal government cannot delegate its power to another. Congress cannot authorize agencies to pass rules that legally bind the public in its stead. Second, the court can kill the judicially created doctrine of requiring federal judges to defer to agency interpretations of ambiguous statutes and regulations. It is a court's constitutional role to determine what the law means in a dispute before it, and it should do so without deferring to any party, particularly not a different branch of government. Okay? All right. The Supreme Court has the chance to end deference in the context of regulations in this term's case of Kisser versus Wilkie. Finally, the court can restore the constitutional fact that all of the executive power has been vested in the president, therefore to exercise that power and see that the laws are faithfully executed, the president must be able to oversee all who work under him. Congress has sought to insulate some federal agencies from presidential oversight by making them independent of the president's ability to remove their leaders or check their actions. But this just creates a politically unaccountable and potentially rogue faction of the executive branch. That's not what the Constitution allows. The Supreme Court should overturn past cases such as Morrison versus Olson and Humphrey's executor, which allowed federal prosecutors or agency commissioners to act free from White House control. The Constitution, as written and understood when enacted, is our supreme law. The Supreme Court has long viewed its own pronouncements as on a par with our founding document. The High Court can restore judicial humility by following the Constitution's original meaning until the people choose to change it. And if the court begins this process of restoration in 2019, it will be a very good year for the Republic. And I agree. Now, I wanted to share that article for a number of reasons, because I came across that article early this morning, and I think that article is important for a couple of different reasons, because what it points out is it points out that the Constitution is the supreme law of the land. Now, just from my experience, going through all of these courts proceedings and things like that, you have a lot of monkey business going on, a lot of circus, a lot of circus events going on here in these cases where you have a lot of actors, you have people swearing oaths to the Constitution, and it's just a mere formality to them, where they don't have any intention on looking out for the person's rights when timely invoked. And we're going to be sharing a lot of proof of that in the near future. We're going to be sharing a lot of different documents we're going to upload on the channel, and we're going to be uploading a lot of oaths of offices up on the channel to show you the rulings that's made. That's clearly a contradiction to the oath, and which is really contrary to the public duty role as the official swore that they would uphold. Now, what I believe that this 2019 will be a very big year. I believe it's going to be a very big year because it's going to allow the common person to understand how to have their rights adjudicated. It's not going to be, we're coming into a time where people are going to come to understand what they actually can and cannot do according to the laws that govern the courts that they go in to get their rights adjudicated. Now, we have a lot of selective things going on here in some of these courts where, okay, I heard this about this person outside of court, so I'm going to do this. Or, yeah, they put this in the paperwork, this person put that in their paperwork, but they didn't do this. Or they're not represented by an attorney, so we're not going to take them serious. Or, that kind of thing. And that's a big bias and prejudice, because you have more people in the country that are not financially able to secure an attorney for $10,000, with the initial retainer fee, or even $5,000. The average person doesn't have that money to pull out, out of their pocket. As you can see, you have federal workers right now that's saying that they're living paycheck to paycheck because of this. They're saying they're living paycheck to paycheck, and then they need their paychecks due to the government shutdown, because as you know, there's been a partial government shutdown, and there's a few federal employees that have to work without pay until the shutdown is over. And so a lot of those people have been on the news and have been voicing their irritation about the whole thing, because they're saying they already live in paycheck to paycheck. So I'm just outlining that. I'm only bringing that up not to talk about politics, but I'm bringing that up to outline the fact that even federal workers and regular workers, they are living paycheck to paycheck. A lot of people live in paycheck to paycheck. So the point that I'm outlining in and bringing those facts forward is that a person don't have $5,000 and $10,000 to pull out of their pocket. So if you're not rich or you're not wealthy, you don't have that kind of money to pull out of your pocket. And all constitutional rights invoked, none waived, for this whole video. And what I would also like to say is we have come into an environment, we have been slowly hoodwinked, okay? And we have been walked into an environment where if you can't give your attorney X amount of dollars and he give that next person X amount of dollars, then you don't get no justice if you can't pay for it, okay? So many of the courts have become casinos, and the judges have become the dealers, okay? You know how it goes at the casino. You get the good luck on your side if you tip the dealer. Okay, so that's what it's looking like. The courts have a great appearance of casinos. All right. So again, we want to bring it back, and we want to have the purpose of me and my brother, making this channel is because we want the average person to be able to be confident in their approach to justice. Be confident even when their processes are being thwarted. Having enough courage to speak and to speak out against this stuff and tell it like it is and say it how it needs to be said. And if you need to cuss, God damn it, fuck cuss. Because it needs to be said. So again, the importance of our channel is to connect with the people who can relate, because at one point or another you will be before a court, and it is very important for you to know how to maneuver in that court. It's very important to know how to look at their tactics that they use. It's very important to have a counter move for every unconstitutional move that they do against you. There is a remedy for everything. And always remember, the fight is never over until you accept the loss. I'm going to say that again. The fight is never over until you accept the loss. Okay? In order for a win to ever exist, the party that the losing party has to accept their position as a loser. When they refuse to accept that position, okay, when they refuse to accept any position as a loss, then a loss is not a loss. It's just a lesson. Okay? It's just a lesson. All right? It's just a guideline. It's just a roadmap to the win. All right? So that is why mitigation is important. Mitigation is very important. Okay? In any situation. Mitigation is important. Because what it does is it allows you to restore balance on the issue and move on with your lives. Okay? So I wanted to point this article out because I think it's very, very important, and it sheds some light on the atmosphere that we're living in today concerning these courts. There's a lot of things going on with the court. The Supreme Court is dealing with a lot right now, and there's a lot in the news lately about the United States Supreme Court and its function. So a lot of people are becoming more familiar with that high court. But yeah, I wanted to just bring this to you guys' attention and shed some light on these issues, because again, the court was not made for people to be intimidated to go into. Those judges have a contract, which is called an oath of office. You will find no state judge that is operating without an oath of office. In none of the 50 states in this country will you find a state judge that is operating without having an oath of office. Okay? It's like that for a reason, because that's a contract to your rights when your rights are timely invoked. All right? All right? Now, for those who've watched the other videos, you hear me talk about implied waivers. Okay? Implied waivers are very important, because implied waivers can deem your rights waived just by you participating in a certain action. All right? So it's very important to be aware of these implied waivers. All right? Okay? All right. Well, I'm going to conclude this video. If you guys have any questions, you know what to do and how to do it. And again, thank you for tuning in, and we will have more videos coming up. And yeah, enjoy.
Bye.